Following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori? Good evening, everybody. Welcome to the following program. I'm your host, Joe Newman, a.k.a. Good Lawgic. Man, I cannot wait to dive into this relatively short and thoroughly inept motion that was filed by Nathan Wade earlier today. And we're going to talk about what, as a litigator, just as someone who's accustomed to, filing motions of my own from time to time, I could tell you what's going through Nathan Wade's mind almost with certainty. And when you hear it, I'm sure you are going to be giddy with laughter. Giddy with laughter. We're going to need to get into that. Humanities topics are going to come at the end of the show. For those of you who get very sleepy, lightheaded when you start talking about Joe's going off on the deep end, talking about his deep stuff here. At least it'll be closer to bedtime. Anyhow, but before we start any of that, it's important, imperative. It's essential. I get a few things out of the way. I made a pitch on YouTube on my community post earlier today where I was apprising you all that I really highly recommend that you sign up to my locals, which is goodlogic.locals.com. As most of you are likely aware by this point in time, if not, I need to club you over the head a few more times because with facts that don't really affect or matter to you very much at all, but that the fact that's relevant to this channel is the fact that my daughter is getting married, God willing, on Sunday evening. This is likely to impact my ability to stream. My sources, at latest count, still show that the Fannie Willis trial will be happening the next morning, Monday morning. I plan on streaming that, so much so that I've already set up the live stream on YouTube. Have not yet set it up on Rumble for two reasons. One, you can never have two pre-scheduled live streams, so I couldn't set it up before this stream. And number two is that Rumble doesn't allow you. You can do that on YouTube, but you can't do that on Rumble. Number two is that another limitation of Rumble is that you cannot set up a live stream more than 24 hours in advance. I don't know why. I don't know. But those of you who are residing in the Rumble ghetto, in the tunnels, them Jew tunnels, hot and out there, away from view, over in Rumble land, who might think, oh, Joe hates us. Oh, Joe forgot about us. Oh, where's my link now, Joseph? Those of you who might be thinking that, rest assured that despite the fact that my daughter, God willing, will be getting married on Sunday evening, sometime during the course of that day, I will create a Rumble link. And 9 a.m., I assume it's starting 9 a.m. We may learn it's 9:30. If I've learned that it's pushed back, I might start a few minutes later. But I expect to be on time for the start of that hearing. Whether or not we'll hear from Mr. Terrence Bradley, whose testimony is, oh, so delicious, I don't know. That is it. We are awaiting a court determination. But we certainly should be getting closing arguments. There is a possibility, because of the motion that we're viewing now, that anticipated resumption of the hearing date may get pushed back a few more days. Right now, it's slated to happen on Monday. There's been no change in that status. I even found an article which is saying that we anticipate it's going to be coming up on Monday. However, I would not be remotely surprised if, given this new motion that was filed by Nathan Wade's counsel, and an expectation that the defendants in the trial, the Georgia RICO trial, likely will be given an opportunity to put in some sort of opposition, and the motion relates to this hearing and how this hearing is conducted, there is at least a 50-50 shot that Monday resume the Fannie Willis hearing expectation may be adjourned until the judge has an opportunity to decide that motion. There's at least a 50-50 shot. So right now, if you follow me on YouTube, well, first of all, God help you if you're not subscribing, because I don't know how you're finding me. But you likely would have seen that I set up that stream. That's because I figured Sunday I'll probably be very busy, and once that stream is set up, it's much quicker for me to set up a Rumble stream and just copy and paste all the stuff that I did there, move it over and mirror that for Rumble, so I can create a Rumble link. So in case there's a hearing Monday morning, I plan on streaming it. I will be on top of it over the weekend and checking that out. But one of the things I made clear in my pitch is that over the next 10 days or so, I expect that my schedule is going to be very erratic. Where from day to day, I'm not going to know in advance whether or not I'm going to be streaming. I'm going to hope to stream. I don't know. But there is week-long parties that our people, my tribesmen, engage in after a wedding. And it is expected. Those parties tend to be in the evening. They don't have to be, but that's just when people are around. In those parties, there is an expectation that the parents of the bride and the parents of the groom will attend every one of those parties. So, that being the case, these parties being hosted by various friends and family living in the tri-state region, and they tend to start at 7 in the evening, 6 in the evening, and run for a few hours. I don't know whether or not some of them will leave me located too far away to actually stream on every night next week, or I might miss a lot of nights next week. I don't know. I really don't know. So that's why I urge you, the only way you're going to find out whether or not I am streaming is if you sign up at goodlogic.locals.com, turn your notifications on. You could turn them on for everyone else. I don't care. But I need you to turn them on for me, because otherwise you're likely to miss me wherever I am. I'm also hoping to stream during the day because my days will be relatively bored. So I'm hoping to stream during the day. I am aware of the Hannah Gutierrez trial, she was the armorer in the Alec Baldwin case. I saw that trial commencing today. I thought about streaming it. I was like, I'm not going to be able to stream tomorrow. Monday, I'm expecting to have the Fannie Willis thing, which to me, that overrides Hannah Gutierrez trial. If I see that the Wade trial or the Fannie Willis hearing is pushed back, I might end up switching in and doing some Hannah Gutierrez trial coverage. I don't know. The only way you will know is if you follow me at goodlogic.locals.com. You don't need to be a paying subscriber. You don't need a code from me to get notifications about where and when, where you can find me and wherever I go on social media, whether it's on this channel that you're watching me presently, or on Twitter, or appearances on other shows. You'll always get notifications. I commit to my locals people that whether you're paying or not, you'll get links of anywhere I make an appearance on social media. And I love having your time and attention. It's always cool when I jump into someone else's stream and I see a face that's in there that I recognize. And I recognize probably several hundred of you by now, if not several thousand. So that being the case, please, goodlogic.locals.com. Got that out of the way. I do plan on streaming. I do hope to join Eric tomorrow on Laid Back Legal and Laid Back Law, whatever he calls it. I don't even remember. And join with a panel of other attorneys. I'm hoping to join there. He already invited me. I'm hoping to have the time to join it. Second of all, I do plan on streaming Saturday night, the day before my daughter's wedding. I will definitely not be streaming on Sunday night. That's the one thing I do know is I'm not going to be streaming Sunday night. But Saturday night, I hope to be here. That's my schedule as of right now. But please, goodlogic.locals.com is where you'll find any as far as where and when I am on all things Lawgic related. Brooks Kelly says, just curious, applying Bragg's logic in New York City case against Trump, where 2017 tax return affected the 2016 election. When a widower marries, does he commit bigamy? I am going to have a lot of fun dissecting. This is my state of New York. That's where I practice. Okay, I'm admitted to practice law in the state of New York. You can look up my name there. You'll even find my registration number. It's 297-4319. as being licensed to practice law in the state of New York. I had my time I spent when I was investing time in working as a lawyer was in commercial litigation. So, which is basically means business disputes. That's just how lawyers say it. So, yeah, I'm very familiar with New York law and New York procedure. New York, especially when you're talking more civil procedure than criminal procedure, although I've gotten more accustomed to it through the course of doing this show. Now, I will tell you, I am looking forward to decimating Alvin Bragg. That trial starting March 25th. I do hope to stream it, although frankly, I'm not going to kid you. Currently, I'm scheduled to have a trial of my own that's supposed to start on April 1st. So I'm supposed to be I have a trial that's slated for April 1st. So I'm a little bothered by that as to like how I'm going to be able to day stream and when I'm going to prepare for my own trial. I don't know if that trial is going to be canceled. When it's settled beforehand, I don't know. But right now I'm currently slated. But I am looking forward to spending a lot of time talking about Alvin Bragg and his misapplication or ridiculous application of the law. But your point is well taken. Rumblers not allowed in digger tunnels like Fanny. They're too ghetto. Commercial litigation does not mean loan shark. No. These are lies. Commercial litigator just means Jew lawyer. That's really what it means. It means New York Jew lawyer. It is. And I don't take offense in that at all. I take it as a compliment. You want to know why I take it as a compliment? Because if you were Tony Soprano, you would want not just any lawyer, you would want a Jew lawyer. That's what you would want. Why would anyone take offense from that? So there you go. I say that with pride. My stream probably just went yellow just for saying it, even though it's a self-comment there. New member of the following, Ed2276. I've seen you around a lot, my brother. Good to see you as a member of the following. The following is not at all a cult type of cult. There are no Kool-Aid, no self-harm, no harming others, no tracksuits that are mandatory, no goat sacrifices, no squirrel mutilations, no smearing blood on the walls, no stabbing yourself with a jabby jab, no throwing virgins into volcanoes. And perhaps most importantly, I am not the leader of the following. I am not the leader. I am a follower just like you, Ed. Just like you. There's no difference. We're exactly in the same boat. So welcome to the following, where we stress greater community, stronger unity, and increased personal growth. Welcome aboard. Joe, just wear an Apple Provisions cord, cover all the things. Probably do that. Dear reader is the best reader. I had to read that like Kim Jong-il. Dear reader is best reader. 10 months, old drill sergeant. Great job. And his prosecutors are bloody awful. Are they? Oh, that's good. That's not good. That's not good. I want to see Hannah face some punishment. I'm old enough. I remember black defendants that wouldn't take a black defensive lawyer, demanded a Jewish lawyer, terribly racist them, I guess. I don't need no black lawyer. That is awesome. That is really, really awesome. All right. I was going to jump in with this whole thing. I was going to share with you an Alex Stein clip, but I'm already 14 minutes into this, and it's a 3-minute clip, and I don't think it's as funny as everyone else thinks it. I think it's okay. But it's not worth 3 minutes. If it was 60 seconds, I would have done it, but it's 3 minutes. It's too long. Joe, law of self-defense is streaming the Hannah trial. When you have the time, you could always join his stream. Yeah, that's true. He is, and I highly recommend his coverage. The dude is awesome. He is awesome. That's where I saw it this morning. I was peeking in, and I almost volunteered to join him on stream which I'm sure he would have sent me a link, but I actually had to go pick up my son and daughter-in-law who were returning from the Holy Land in order to, as all the chickens fly home in expectation of my daughter's wedding. So, and that was a 4-hour trip coming from here to JFK and back. Oh my God, that was difficult, but very excited to have them home. Since when do we cancel goat sacrifices? Why? What do I have to do with my nanny on the altar? Look. If you want to sacrifice a goat, that's your prerogative. We don't ban. I want to be clear. There's no banning of goat sacrifices. I'm simply saying that's not a required part of being a member of the following. It's not like we say, "Oh, join the following. Now you have to go. Butcher Billy." No, you don't have to. But those of you who were in the practice of engaging in goat sacrifices prior to your commencement of your membership in the following should not feel as if all of a sudden now you're going to have to reach into the bowels of a belly and start excavating all of its vital organs. That's not going to happen. That's my point. That's really my point. All right, so we're going to skip on Alex Stein because that's just too much. I do want to share with you some really interesting thing. This was shared on Locals. One of the advantages to Locals, you get to see some links from some of the people that some people post up there sometimes, in addition to getting live streams that I'll cover on there where I sort of will share some of my thoughts. There's my little one. Hey. So I basically... this was a link that was shared on Locals, and I was like, oh wow, this is a happy day. So I just want to share this with you before we get to Nathan Wade. Right after this, we're going to jump into the Nathan Wade motion. I'm going to explain to you just how terrible the Nathan Wade motion is and what it exhibits about his levels of fear. Oh my God, he's afraid. Oh, he is so afraid. Before we get to that, I just want to share with you this quick story, which I'm not going to go the whole way through the story because it's the Los Angeles Times, and they managed to find ways to just write 20,000 words about nothing. So yeah, that's not Lord knows I hate when anyone is too wordy. I can't stand it. I'm totally against anything that's too wordy. So this is what we got here. Judge clears charges against alleged white supremacist, says there's a bias against the far right. Ooh, look at that. Wow, the LA Times obviously very freaked out about the fact that these alleged white supremacists were let free. Now, I will tell you, before I read any further, based on the allegations, these are not white supremacists the way they tend to call you and me white supremacists. Some of them seem to be kind of racist, but there's still freedom of speech. And if you increase levels of prosecution against someone just because they're a racist, that's pretty much infringing on their freedom of speech rights. But an Orange County federal judge has dismissed criminal charges for the second time in 5 years against accused members of a Southern California white supremacist group suspected of inciting brawls at political rallies throughout the state. U.S. District Judge Cormac J. Carney on Wednesday dismissed charges against Robert Rundo, who was extradited from Romania last year, and Robert Bowman of Torrance. I don't know what Torrance is, but these are two individuals who are being charged. The two were charged with conspiracy to violate the Anti-Riot Act and rioting. Rundo, alleged to be a founding member of the Rise Above movement, or RAM, a white supremacist group, and this is according to the LA Times, they seriously, they say that if you say there's two genders, you're a white supremacist. So I don't know whether or not they actually are. They may be an actual, white supremacist group, or they might be a Los Angeles Times perspective of white supremacist group. I don't know anything about Rise Above movement at all. So I don't want anyone to think that I am castigating them or condoning them, because I'm just ignorant when it comes to this particular fact. So I'm going to say RAM, an alleged white supremacist group that, according to federal indictment, touted itself as combat-ready militant group of new nationalist white supremacists. Okay, that sounds pretty racist. That sounds, if that's how you're calling yourself, new nationalist white supremacy and identity movement. All right. I'm gonna I'm going to dial back a little bit here. Say they're likely genuinely white supremacists. Likely. I'm going to lean toward they're probably white supremacists. I don't care. Law applies the same to them. Bowman was an alleged member of the group. In his decision, Carney granted defendants motion to dismiss, agreeing that Rundo and Bowman were being selectively prosecuted, while far left extremist groups such as Antifa were not. And this is the interesting thing. He's really bothered. He's like, why do we never see anyone here who's part of Antifa when we know they're engaging in violence? We never see that. You see all these charges against these, right-wing extremists. Never against left-wing. Prosecuting only members of the far right, ignoring members of the far left, leads to the troubling conclusion that the government believes it is permissible to physically assault and injure Trump supporters to silence speech, Carney wrote in his order. Here. It's not even like saying that they're okay. It's not what it's saying. It's saying you guys suck at prosecuting Antifa, and I'm not basically going to I'm not going to see any of these charges move along until such time as I get an Antifa defendant in here first, because I'm tired of seeing all these far right extremists brought in here. Quote, there seems to be little doubt that defendants, or at least some members of RAM, engaged in criminal violence, but that they cannot be selected for prosecution because of their repugnant speech. And he calls it repugnant speech, and it probably was repugnant speech, and beliefs over those who committed the same violence with the goal of disrupting political events. Bowman was already free on bond while Rundo was still being detained. Prosecutors on Wednesday requested that Rundo remain in custody pending the government appeal, which Carney denied. He said, get out of here. You're free. Quote, I don't believe it's warranted that Mr. Rundo spend 1 minute more in custody, so I'm going to release him forthwith, which is another way of saying, right now, buddy, go, run. Run, Forrest, run! I feel very comfortable with the decision I've made. The government responds by filing an emergency motion to stay Rundo's release and keep him in custody, but too late because he's out of here. Rundo is living up to his name. That dude is running so fast, so far. The motion said Rundo, quote, presents a grave risk in flight, as well as danger to the community, and it asked that the release order be reversed. The government requests relief by February 22nd, 2024, meaning right now, please, for the love of God. So it's to safeguard against Rundo's potential flight from the United States. On Thursday, the Court of Appeals of the Ninth Circuit issued a stay on Rundo's release. And they said, oh, no, Judge, you shouldn't just let him go running off like that, pending the resolution of the government's appeal. But according to the FBI, the Federal Bureau of Prisons inmate locator, Rundo had been released the day before. He gone. When asked what would happen with Rundo now out of custody, a spokesperson U.S. Attorney's L.A., which prosecuted the case, said the office would advise the developments as appropriate, meaning we're trying to track him. It's interesting because it's an interesting question. Just because you're allowed to retain him in custody, does that mean you're allowed to now, because there's a stay, does that mean you're allowed to now go after him? I don't know. Sounds like it's probably in the same sphere. Sounds like it is. I don't know. You'll get those extradition if he flies back to Romania. I don't know if you can get those extradition papers just signed off really fast. If I was Rundo's attorney, I'd be like, dude, get your freaking passport. Get on a plane. Don't tell me where you're going. Don't tell nobody where you're going. I'm not giving legal advice here. I'm simply saying some criminal defense lawyers might advise him that, hey, look, you probably don't want to stay in the contiguous 48 for sure. Probably don't want to rely on, the remain in Mexico policy because, Trump's not here. I would just pack your things, take your toothbrush, your wallet, your keys, and if you forget any of those, that's okay. Just get on the plane. That's definitely what happened. Anyway, story goes on and on. As you can see, there's a little thing over here showing that this story just goes and goes and goes. I'm not. I think we got enough of this story. I got enough of this story. And ultimately, the call ends up being mine. So there you go. Doesn't that stop goat meat being kosher? Goat meat happens to be kosher, actually. You just can't do the sacrifice. Sacrifices, we don't have sacrifices. Okay? We don't have sacrifices. Now, yeah, we don't have sacrifices. I need to get to Wade. I walked into an LA bar called Ram one time. I was gonna say it's like they think it's like a tough name. It's a tough name. I don't know. I don't know. I have a feeling that a bar named Ram is probably not. First thought that comes to mind is not that it's a white supremacist bar. Not that. Not that. Orange County is pretty conservative. Yeah, there you go. Yeah, this group are friends with Linda. I don't know. Oh, the group that, which group? Which group? I don't know what you're talking. All right. That's gonna go. Let's get into Nathan Wade. Nathan Wade. So I need to remind you as we're getting into this, here's his motion. Here's his beautiful, beautiful motion. When I say beautiful, I mean hilarious. This is his beautiful motion. We will be reviewing it. Fortunately, it's only 12 pages long, frankly, because they ran out of crayon. And I need to give you some context here because I realize that many of you are very interested in this hearing, but some of you might have failed to catch every moment of riveting testimony that I was live streaming last week. And I understand you have lives. And if you missed near the very end of day 2, it was only 2 days of hearing that we had, near the very end of the whole thing, one of the last witnesses, but I will remind you, not the very last witness, but one of the very last witnesses during the last hour that we were covering this was an individual by the name of Terrence Bradley. Who is Terrence Bradley? Terrence Bradley is an attorney licensed to practice in the state of Georgia. One would presume I'm not speaking to his reputation or his abilities, although the district attorney's office seemed to think that he was very, very capable and actually retained his services for purposes of examining taint. I'm not going to ask what that means that he was hired to examine taint. Many of you likely would think that the first choice that Fannie Willis would have for a lawyer examining taint would have been Nathan Wade. But apparently she gave it to his partner, Terrence Campbell. Now, yeah, and that's not going to happen. But welcome aboard, new member of the following. But it's not even streamed. It's not even, they don't even have like video in there. So no, that's not going to happen. I wouldn't mind if people saw it. They just don't have, it's not going to happen. Yeah. So, okay. So getting back to this, so Terrence Bradley is a Georgian attorney. And he's a friend of Nathan Wade going back to the 90s. And they opened up a law firm together called Wade Bradley Campbell. I think it was Campbell. It might have been Cooper. It was some relatively common C name. I'm going to say Campbell because who cares? He's not in the hearing. No one cares. He's not really in the story at all. They actually called their firm the WBC firm, Wade Bradley Campbell, which I had to admit was a pretty good name. That's a pretty cool name to have for a law firm, the WBC firm. Ooh, that's sounds kind of badass. Then Bradley left, and it was just the Wade Cooper or the WC firm. Not nearly as cool. Not nearly as intimidating. Somehow the WC firm is just not. If it had been the WB firm, you would think, okay, maybe that's got some appeal to a certain demographic that they likely would be appealing to. So, although according to law of self-defense, not as appealing as I don't know, as Kagenkite, but yeah. I can say it. If black people can say the N-word, I can say it. No one can stop me. No one can stop me. All right. Anyhow, so during the course of testimony, it became clear, and we definitely know that at a certain point, Nathan Wade retains Terrence Bradley to be his divorce attorney. Now, he doesn't get divorced until November 2nd, doesn't file for divorce until November 2nd, 2021, one day after he signs an agreement to serve as special prosecutor for Fannie Willis, which was November 1st, 2021. The next day is when he files for divorce. During the course of his divorce, at some point, Bradley is removed. He's replaced by different counsel for Nathan Wade. Apparently, there are certain communications which counsel for Roman, which is Trump's co-defendant, Michael Roman. So counsel for Roman had been engaging in text conversation, asking Bradley if he was aware of any of when the personal relationship between Nathan Wade and Fani Willis first began. And there were intimations during the course of those text exchange that he had knowledge as to when it began, and that potentially it began well before November 1st, 2021. This is very important in the mind of the court, because we have to remember, what is the court focusing on in this hearing? There's all sorts of different bases that Michael Roman's attorney raised as to why it is that Wade and Willis need to be removed. They said that they're looking for fame. They're looking at this is all about building up their public persona. Judge said //////. I don't care about any of that. The only thing I care about is this one weird thing that you're saying here, which is that they had a romantic relationship, which was the motivation for Fani Willis to hire him, and that she's basically shuttling a ton of money to him for the purpose. Now they're going around on all these different trips that he's treating her to, which sounds like that she's self-dealing, that she's like, oh, if I give money to my boyfriend, he'll be flush with cash and be able to take me out on all these fancy schmancy trips. So that sounds really, really like bad. That sounds really bad. The yardstick is supposed to be that if there's not that you have to prove that there was some sort of self-dealing there, but if it feels like we're lacking in integrity, you're supposed to remove the district attorney. You have the appearance of impropriety. Now, he said that to me is the appearance of impropriety in the prosecution of this case. So that's what we're going to have a hearing about. Now, enter Terrence Bradley. Terrence Bradley here comes along, and he basically now hopefully is going to be submitting some sort of evidence, at least in the minds of the defense, walking into this hearing. Well, Fani Willis, Nathan Wade first is the one who admits it first in his affidavit in opposition to the motion, said, yeah, we had a relationship that was going on, but the relationship didn't start till months afterwards. Plus, she paid back all the money that I laid out for her. She paid that all back to me. And here's proof. You want your proof? Here's proof. I know I spent thousands of dollars. They found all this documentation showing that I spent thousands of dollars, but here's proof here's one time that she paid $900. When they got to trial, it's not really a trial, it's really a hearing. When they got to the hearing, we're taking evidence. First witness come out of the box, and this is really where the ball started rolling downhill for the prosecution. First witness come out of the box says, hey, I'm friends with Fani Willis. Our friendship goes back decades, and she told me back in 2019, late 2019, early 2020, that she's dating Nathan Wade. Now, this is an interesting thing. And we need to focus on admissions that were made by Wade. He admitted we had a relationship, but they claim the relationship didn't exist in November when I was hired. No. She hired me, and then the relationship began 3-4 months later in March, April 2022. That's when our relationship first started. But we didn't have no relationship. We didn't have no relationship when she hired me. Okay. All right. Okay. Now, there was a lot of interesting and compelling evidence to refute that claim. And I don't want to go through all the particularities because I really want to get to what this motion is all about in order for us to better appreciate what this motion is and why it is that I think it's a steaming pile of garbage. I'll get there. We're working our way there. There's a lot to this story. So when Bradley is put on the stand, he has his own counsel now. Now, we know that his relationship with Wade, his business relationship with Wade, ended like a year or two ago. When he gets up on the stand, his attorney, Chopra, gets up there every time he's asked a question, anything about his relationship with Wade. Objection, attorney-client privilege. Objection, attorney-client privilege. Objection, attorney-client privilege. And the judge would sometimes make some inquiries. He's like, so this that they're asking about, this question here is when you first spoke to him, when is that privileged? He's like, yeah, that's privileged also. Yeah, that's covered by the privilege. Now, here's the interesting thing. They're claiming the privilege starts in 2015. Mind you, he doesn't file for divorce for 6 years. 2021 is when he files for divorce. Now, that's a bit much. And the judge seemed a little suspicious of that. I'm just giving my own personal opinion. Because the judge never found a timeline as to when does this attorney-client relationship commence. If he comes along and he says, I'm in a fight, but there's no thoughts of him divorcing her, it's hard for anyone to say that just because he's in a fight and later he ends up becoming counsel, that there's an attorney-client privilege. And the commencement date of this attorney-client privilege is something that's a little amorphous. And it becomes that much more amorphous when we consider the fact that Bradley admitted he's not sure that a retainer agreement was ever signed, which is not that crazy because attorneys who are friends with each other for decades, you can understand him saying, I'm not going to be charging you the normal rate. I'll go in there. I'll take care of you. You're sort of serving as a buddy, but you're still his attorney. And it's very amorphous as to exactly what point is he helping guide him, giving him advice that Wade is making admissions to him about relationships that he has, that he's talking to him as a friend, or talking to him that he's seeking legal counsel. And this is something that, like, okay, well, how do we know what the nature of it? The only way we know this is if the attorney who's ultimately retained tells us. We don't know otherwise. There's no way for us to know. In theory, it could go back 6 years. That sounds like a really long time. But, he according to Wade, he's like, yeah, I felt like I was divorced ever since 2015 when she cheated on me. Yeah, that B cheated on me, and ever since then, we've been divorced. Okay, well, certainly not from the eyes of the law, but does that mean that he's your attorney now when you're not thinking about getting divorced? Why didn't you get divorced then? Those questions as to why he didn't get divorced 6 years earlier when the relationship was over and when our marriage was finished. So I think he ended up testifying. I think he might have been asked about that. I think he said the reason was because he had kids or whatever. And they thought it'd be better to wait until after the kids were out of the house. Okay, look, I don't know. You might think that's a stupid idea, but that doesn't mean that wasn't what guided them to wait. A lot of people act based on stupid ideas. So it could be it was their stupid idea. And that could be what happened. But does that mean that every time he talks about anything, that it's in the pursuit of legal advice? He comes and he says, hey, he comes in there, he's like, dude, I'm a mess today. This girl wore me out last night. Is he looking for legal advice? Hard to say, yeah. And if it's not pursuit of legal advice, but just two friends talking, that's not privileged communication. Well, anyhow. So they have Bradley on the stand there. And when they get Bradley on the stand there, and they're asking him all these questions, and it's constantly objection, attorney-client privilege, objection. His lawyers keep standing up. Objection, attorney-client privilege, objection. And the judge is giving very broad leeway to that. He's like, all right, look, if the attorney's saying it's attorney-client privilege, how do I know it's not? Attorney-client privilege is really important. Wade certainly hasn't waived attorney-client privilege. So, but he's like, sustain. So he's sustaining it over and over again. And then the state did something really stupid. Really, really, really stupid. Because when he's asked about, at a certain point, when he's asked by the defense, why did you leave the firm? What happened? He led the firm. Was it something related to was it something that's related to Fannie Willis or your divorce? It's like, no. It's like, well, why'd you leave the firm? It's like, it's privileged. It's privileged. Well, sure enough, Abby Cross for the state does the cross-examination of Terrence Bradley, and she starts pressing him about why he left and saying, "Hey, who's Anna Rodriguez? And isn't it true that you were accused of engaging in illegal touchings or improper touchings, and that there's been complaints filed against you, and that's why you left the firm?" And the judge is like, "Why are you asking these questions?" And he's like, and she's like, "I want to show bias, that he's biased against Wade," which I don't understand what the hell that means. Because if he was just even if he left under allegations of misconduct, we'll call it SA. So even if that's how does that establish that now he hates Wade? Why would that be that now he hates? How you get that tie in? I don't know. But he starts expressing about this. And we come to this moment. We come to this moment right here. Ultimately, when he starts expressing why it is and denying it, and then starts making some admissions along the line that, that led to like a little bit of a falling out. So at least the judge being very confused. He's like, "I don't know what's happening here. Before you tell me it's privileged." No. Let's check it out.
What he has just responded to. What
he
just responded to. Privilege. He previously said was privilege.
No!
Just responded to. That doesn't sound like privilege. Address that.
Well, that's not good.
That doesn't sound like privilege. All
right, Boomer.
Address that.
Miss Cross. For the love of God.
Okay. Mr. Stay down. Mr. Stay down. Okay. Mr. Stay down. What he has just responded to. What he has just responded to. Privilege. He previously said was privilege. That doesn't sound like privilege. That doesn't sound like privilege.
It's not.
That doesn't sound like privilege.
Oh my God.
Address that. Miss Cross. Go back to the run.
I thought it would end.
Mr. Stay down. Mr. Stay down.
All right. Well, that was a nightmare. My God. Wow. I thought the boomerang would end after one. The problem isn't me. The problem is your ears are like listening to everything in real time instead of in staccato time. If you were listening to things in staccato time, that would have sounded perfect. It would have sounded perfect, but you weren't. So that's why that didn't really work nearly as well. Let's try this one more time. I'm gonna try this one more time, for the love of God. That's not going to work.
What he has just responded to, he previously said was privilege. That doesn't sound like privilege to me. We'll have to address that when we go back through the rundown. So, Ms. Cross.
Doesn't sound like privilege. What he just called privilege doesn't sound like privilege to me. And so he's like, "I don't know what's happening here." That's Mr. Bradley in the lower left corner there. All confused about what the word privilege means. He is a Georgian attorney. All confused about the word privilege means. Because he says, the reasons I left the firm are privileged information. And then when he starts explaining why he left, there's no privilege to that. That has nothing to do with privilege. Now, Abby Cross realizes that, oh my God, I just opened up a whole Pandora's box. So her response to that is great.
Ms. Cross.
I'm finished.
I'm finished. Oh, you finished. Oh, you finished, girl. You finished. Oh, my.
Okay.
Oh,
Mr. Stay down.
I don't know if this is helping Wade. How is this helping Wade exactly? Yeah. So that was what happened initially. That was followed up. With this.
Bradley previously testified that the reason he left the firm was totally and completely covered by privilege. When asked by the state, he went into a factual scenario that, to my mind, I don't see how it relates to privilege at all. And so now I'm left wondering if Mr. Bradley has been properly interpreting privilege this entire time. And I think the only way I can cure that is by having that in-camera conversation with him.
So to clarify, what the judge ended up saying there was, I don't really know that this lawyer understands when there's a privilege and when there isn't, because he just said privilege in a situation that there's no privilege. Now, all along, he kept saying privilege, 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 privilege. And now he's saying privilege. And I know he's wrong now. I know he's totally wrong now. I didn't know the facts that led to I don't know what facts were the underpinnings of his privilege assertion an hour ago. But I know now that sometimes when he uses the term privilege, there's no privilege. And I've been reliant on his claim of privilege throughout this entire time. So now I got to start reassessing here. He said, "Well, I can't talk about what happened with Wade. I can't talk about what he told me about Fannie Willis because that's all privilege." Really? Really? Because I don't think you know what that means. I don't think you know what that word means. What does privilege mean? When does it attach? Where is there privilege? It doesn't seem like you really understand what the hell privilege is. So he's like, we're going to have an in-camera discussion. I'm going to have a little side thing. I don't want everyone else hearing it, but I'm going to need to know a lot more. So that's called in-camera, meaning no cameras in the court's camera, but no outsiders are going to be privileged to see it. So that the court has an opportunity to assess the legitimacy of his claims of privilege. So he's going to ask some questions like, what perhaps about text messages, perhaps about, natures of communications, and what did he say and what didn't he say, and when did he say this? And you would think that if everything here was above board, that should be okay. That should be fine with everyone. It's like, all right, look, if it's not something that's going to be admissible, if it turns out that he's right, that it was privileged, so then the judge will say, like, yeah, okay, that's privilege. That's part of his consultation for an attorney, and that's all privilege. Now I'm not going to bring that into everything here. And yet we have this motion. We have this hilarious piece of drivel motion filed by Nathan Wade's attorney, Special Prosecutor Nathan Wade's post-hearing brief on in-camera examination of attorney Terrence Bradley. Come now, Special Prosecutor Nathan Wade, by and through the underside counsel, and files this post-hearing brief concerning in-camera examination, meaning the reason I'm filing this is because I know you're planning on having a conversation with him, and I don't want you having that conversation with him, which may unlawfully compel Bradley to disclose communications with Wade that the court has already determined are protected by attorney-client privilege from any disclosure to any person, even you, Judge. Nothing under Georgia law authorizes the court to conduct such an examination once the determination has been made that the attorney-client privilege exists. And should the court compel the disclosure anyway, it would vitiate one of the oldest and most fundamental privileges recognized both at common law and by statute. And I will tell you this, attorney-client privilege is held to be sacrosanct, inviolate, impenetrable, hard as steel. Can't get in there. The reason for that is because we want people to feel completely comfortable admitting to the worst of their sins to their attorney so they can get proper representation. Because if the attorney is left uninformed because the client is inhibited from expressing themselves, in that case, you're not going to get adequate or complete representation to the best of the attorney's abilities. So we need to keep that attorney-client privilege really, really airtight. However, that does not mean that if you represent someone at some point, that any conversation you have with him in any context, in any setting, all of a sudden goes into that vault, into that panoply of different conversations that are genuinely privileged. In other words, in order to get that privilege, you have to establish that the communications are part of the attorney-client relationship. And it does not seem that Mr. Bradley understands this. He seems very confused about what's privileged, what isn't privileged, which is what led the judge to say, I need to have conversations with him in camera. Now ask yourself, why is Wade so desperate to stop this? Let's go a little further in this introduction. Moreover, the defendants were allowed broad leeway to pry into the private life of Special Prosecutor Wade in an unprecedented public manner. Which, that's true, they were. Spanning 2 full days of testimony, defendants sought to introduce intrusive and legally irrelevant, no, not legally irrelevant, the judge actually said these are legally relevant, personal details of multiple people's lives for the world to watch unfold in real time and laugh their asses off. But still no credible evidence exists that in the record to support their tenuous claims. That's not true at all. There's a lot of credible evidence in the record, like, I don't know, Fannie Willis's bestie saying she told me that they were dating back in 2019, early 2020, 2 years before she hired him to be special prosecutor. If the court were now to disregard the most sacred of all legally recognized privileges, which, okay, probably is the most sacred one, whose preservation is essential to the just and orderly operation of our legal system, it would be a step too far, and Special Prosecutor Wader is constrained to object. Oh my gosh. Why? Why? Ask yourself this. Why is Wade so afraid of the judge getting a look and a listen and a feel for the nature of conversations that were conducted between Nathan Wade and his counsel, Bradley? Now, okay, fine. I understand there's attorney-client privilege. I get that. That's true. That's definitely all true. But the point to attorney-client privilege is that it's not going to be entered into the record. And if the judge recognizes the privilege after having, the judge hears it privately. Let's look at the judge having 2 hats here, 2 different hats. One hat is that he is the trier of fact. He's supposed to sit there and decide what facts do I think happened in this whole set of circumstances. The other is as a trier of law, where he's making legal decisions. Let's assume that this was, let's look at him as being 2 different entities. Normally, the trier of fact in a criminal trial would be a jury. They are exclusively trying to determine what facts happened. What were the facts? And say, this is what we think is what happened in this case. That's what their role is. Questions about what the law is in that set of facts, that's for the judge to decide. So when the judge is taking both roles, stepping into the role of being judge, finder of law, and jury, finder of fact, we sort of ask the impossible and expect the impossible of these judges, that they can look at it from 2 different sets of eyes. And that when he's looking at it in camera, in his own chambers, he's not doing any findings of fact. He's supposed to be looking at it and saying, okay, trying to reach his findings of law. There's a little minimal finding of fact that he has to be doing there, but that's not part of the broader context of the overall hearing. So if he was to see something in there that was perhaps damaging to the state, as a matter of law, he would be obliged to pretend he didn't see it, because if it falls under the privilege, even if he saw it, if it falls under the privilege, he would be obliged to pretend he hadn't seen it, because it's not part of the record. It's not part of the official set of evidence that's been admitted into the hearing. So he can't use that in reaching his final determinations as in his role as a finder of fact. But what they're terrified, what to me seems almost painfully obvious, and I'm sure to Judge McAfee seems equally painfully obvious, is that they are terrified, frightened, silly of the idea that he's going to question Bradley and or look at text messages between Bradley and Wade. Because you need to understand a few things about these circumstances that I laid out as to the broader context of this, well beyond Donald Trump. Nathan Wade, as an officer of the court, special prosecutor, serving under Fannie Willis, and you can translate that any way your little heart desires, submitted an affidavit, a sworn statement under oath, that said, I did not have a relationship with Fannie Willis in November of 2021, and that relationship did not begin until March or April of 2022. Then he took the stand and repeated those same claims. I did not, swearing under oath before God and the court, that he did not have a relationship, a romantic relationship with Fannie Willis until March or April of 2022. Now, if the judge is in camera and he's looking at text messages between Willis and Wade, between Wade and his attorney Bradley, or he hears Bradley say, "Oh yeah, well, sometimes he would talk to me about tell me that he was in love with Fannie," or things of that nature. Is that part of his counsel? Is that part of does an attorney need to know that he's in love with this woman? Is that really helpful to him? So if the judge ends up hearing different facts which make it obvious that Wade perjured himself on the stand, swore to the court, both in affidavit and then in live testimony in front of this judge, and completely flat out lied, saying that there was no relationship in November 2021, when in fact there is virtually irrefutable evidence that their relationships started well before November 2021, or even just a month before. This does not simply imply that Wade needs to be removed from this case. Arguably, this would mean he can be suspended as an attorney. Nathan Wade could be disbarred. These are very real potential punishments that he's facing. If the judge was to see these communications and see that this guy lied under oath, committed perjury for the purposes of trying to keep his prosecution going. And it doesn't just affect him, because Fannie Willis also swore under oath that their relationship did not begin until well into 2022, months after she hired Nathan Wade. And if there's evidence there that their relationship started well before November 2021, that is blatant perjury. You can't ignore that. You can't just pretend that didn't happen. You can't sweep that under the rug. You can't pretend that doesn't show a ridiculous level of bias here, that they're so desperate to stay on this case that they're willing to go into court as officer of the court and completely make crap up and then try to hide behind their privilege for the purposes of basically saying, no, you can't catch us. You can't look at us. We're not here. Don't look at me. Don't look at me. This could literally, if he looks at these documents, if he looks at this evidence, if Bradley answers questions in the wrong way and can document it with various text messages between him and the court, and the court commences an investigation, this does not merely end potentially any possibility of Willis and Wade prosecuting Donald Trump and his co-defendants. No. This potentially ends their career. This is a career-ending move. An utter humiliation for the rest of their lives, that their attempts to destroy Donald Trump led to the destruction of their legal careers. Because that's what they're potentially facing in a worst-case scenario. Is that what's going to happen? I don't know. But I'm going to tell you this. You don't file a stupid motion like this one unless you are friggin' terrified. And he is friggin' terrified. Because I'm going to tell you something. We're going to go through this motion and I'm going to show you how stupid this is. How thoroughly illogical this is. How there's no way a judge can say, oh yeah, that makes sense. Yeah, I think that yeah, I agree with that. No way. No way. It's so bad. It is so bad. We'll get to how bad it is in just a moment. I I dated a Jewish girl in the 80s. Don't tell me you don't have sacrifices every day. Every day, she made it quite known they were required. Really liked you and Jeremy from Geeks and Games interaction on Valiant Show. Oh, thank you. Thank you very, very much. I don't know who Jeremy is. Who's Jeremy? Oh, the guy at the end? The guy who showed up? Is that Jonas? There's Valiant. There was WDW. Is WDW Jeremy? I don't know his real name. I don't know. Maybe it was a different appearance. I'm not my most recent one. But thank you for the support. I appreciate you, JH Schwabach. Thank you so much, brother. I'm confused about the whole Georgia law system. We're all confused right now. Attorney-client privilege sacrosanct unless Trump. Touche. Well said. That's true. They didn't care about it with respect to him. They went right to his attorneys. To the public eye, they're definitely hiding something. Yeah. McAfee is in a very, it is an unenviable position because whichever way he goes, he now is forced to basically make a decision that at least 10 million people will say was biased. Whichever way he decides, there will be 10 million people who say that judge is friggin' biased. It's going to be appealed also. He knows that. You're forgetting Fanny has the prerogative that she wasn't dating him until later than he was dating her, right? That was funny. That was funny stuff. Although arguably, according to her, maybe they were in love before. Maybe to her they were dating and they just hadn't consummated. In which case, to him they weren't dating yet. Because according to Fanny, a woman basically is dating as long as they're in the romantic entanglements. On an emotional level, and that for a man, the dating means on a physical level. So, yeah. Anyhow, I think we need to get into this. We need to get into just how stupid this motion is. It's so stupid. So illogical. Real Patriots Party says, Joe, you suck. That's why we love Jew and waste money on Jew. Sincerely, the non-followers of the non-leader that we don't follow while following the following program, non-cult. Got it? I do get it. Thank you, RPP. You call him RPP? No, you and me. You call him RPP? All right, where we at? Oh, here we go. All right. So, what they're asking for is essentially that the court should not conduct the examination under any circumstance. You shall not look. You shall not pass. Nothing is going to raise the judge's curiosity more than telling him, you're not allowed to look at this. No looksies over here. The attorney-client privilege communications at issue between Wade and his own former attorney Bradley made during the course and in relation to Bradley's representation. Wade must be protected from disclosure, but we don't know when that relationship began. We don't know. We don't know the nature of it right now. We know nothing about this. They never signed a retainer. By the way, Bradley also said, now that doesn't mean there isn't an attorney-client privilege. There is. And the judge recognized that. And they'll talk about how the judge said you don't need to have a retainer to have an attorney-client privilege. That's true. And I agree with the judge's decision on that. Look, I can't speak to Georgian law, but I know that's the case in New York. You don't have to have a retainer to be have an attorney-client privilege that, at least with respect to the privilege attaching in favor of the client. Someone calls me up and says, "Hey, I have a legal question. I have a situation I'm dealing with. I need your perspective on it." And they're thinking about hiring me. That the attorney-client privilege attaches right away. Boom. Even if they never hire me, attorney-client privilege attaches, and for me to go and spill that to someone would be a breach of my ethical duties. So yeah, for it to happen 6 years beforehand, and that every conversation in between, every one of them is in furtherance of because the whole point to the attorney-client privilege is we want you to be able to be free to talk to them and tell them things that may be relevant to your ability to represent them. Does that mean that every time he says, "Hey, I'm sorry I came in late today. I was in Fanny's apartment and I was exhausted because I spent all night whatever," that that's seeking guidance, that he's seeking legal guidance? Really? How is that seeking legal guidance? That's guy talk. That's not, it doesn't attach to all your guy conversations. So no, it's just not reality. Any decisions of the court to the contrary would fly directly in the face of long recognized public policy to encourage full and frank communication between attorneys and their clients and thereby promote broader public interest in the observance of law. Let's look at their argument here, and we'll see why there are problems with it. Attorney-client privilege is the oldest privileges. Yeah, okay, we got that. Long recognized, attorney-client attaches when legal advice is sought from an attorney and operates to protect from compelled disclosure any communications made in confidence relating to the matter on which the client seeks advice. Okay. Relating to the matter on which the client seeks advice. And how do we know this? It doesn't seem like Bradley understands this law. He thinks it's just once you retain me, the rest of our conversations are privileged. That doesn't seem, that's definitely not an accurate reflection of it. The protection from compelled disclosure applies under every circumstance, whether in court or in camera, unless either an exception is proven or privilege is waived by the client. Yeah, or unless there's not really attorney-client privilege. It's not, unless it's not protected speech. That's the problem. Unless it's not a protected communication. If it's not a protected communication, none of this applies. None of this applies. And here's the problem. Here's the problem that he's going to face here. The court has already held at least 14 times that attorney-client privilege applies to communications at issue. Yeah, that's kind of the problem that you have. You think this is helping you. You think if this is here's why I think this is a lousy motion. The thrust of their case is what actually harms their case. Say this again. The thrust of their case is actually the flaw in their case. As the court has already acknowledged, the record clearly shows that an attorney-client relationship was formed when Special Prosecutor Nathan Wade hired Terrence Bradley to represent him in his divorce in 2015. No, the court didn't say that. They say it could, he said it could attach. And he gave broad deference to Terrence Bradley's opinion that the privilege attached. That's the problem. He gave him deference in his assumption that okay, here's a Georgian attorney. He's telling me the privilege attaches. I assume that he knows when it attaches. So he tells me that he was asked to represent him in his divorce in 2015. I don't know that he even knows what the hell that means. The attorney-client relationship existed at least until late 2022, and the attorney-client privilege continues through today. Okay, well, at some point it attached. Like he filed divorce papers. It's irrefutable that at some point there's an attorney-client relationship. The relationship was in the context of Wade's divorce proceeding. Okay. Any alleged communication made by Wade to Bradley concerning alleged personal relationships would have been made in confidence and would have been directly related to the matter which Bradley represented Wade. No, there was never a finding of that. Never a finding of that. That's just not true. That's not true at all. Nowhere you're going to find anywhere in the record that he says any personal relationship conversation, that's privileged. Why? Why is that? If it wasn't in furtherance of his representation? If they haven't talked about the idea of him divorcing him in the last 3 years, 2015, he has conversations saying, you know what? I'm sick of my wife. I want to leave her. He's like, all right. Let's assume he says, all right, when that happens, you let me know and I'll represent you. I'll take care of you for free. Let's assume that was the conversation they had in 2015. That means every time that he shows up and he's like, dude, you had to see this chick I met last night. She was awesome. That's attorney-client privilege? Really? Really? Why? Why would that be? So, no, this was never found by the court. This is a misrepresentation as to what the finding of the court was. And 5, Wade has never waived attorney-client privilege as relates to statements made to Bradley in the court's representation. Well, that we got. Okay. The court specifically found, I think the law is clear, that money doesn't even have to change hands. See, here they're making a quotation. You want to know why? Because this is an actual accurate part. This part is accurate. I think the law is clear that money doesn't have to change hands to establish an attorney-client relationship. I'm making a finding based on the evidence that has already been presented, namely the fact that he signed pleadings and attend depositions on Wade's behalf. So I know at some point he's his client. an attorney-client relationship did exist at some point. But did it exist in 2015? Did it exist in 2019? Did it exist in 2020? Papers were not filed until well into November 2021. November 2021. Did it exist on January 1st, 2021? Why? Who says who? Oh, you know who says so? You know who told the court that? Terrence Bradley. You know who the court found doesn't know when privilege attaches? Terrence Bradley. That's your problem. Your problem is that your stupid cross-examiner, Abby Cross, was so afraid of his testimony, which really wasn't that damaging to Wade, so afraid of it that she basically displayed to the court that this dude doesn't know what privilege is or when it attaches. And I can't tell you how Steve Sado jumped for joy. Like, I'm telling you right now, if you saw him there in the courtroom, it's like all of a sudden he just got like 4 inches taller. And you're like, dude, what just happened? Oh, yeah, Abby Cross just like basically made our case for us. Thank you, Abby. We didn't know that this guy was some sort of deviant, or that the state thinks he's some sort of deviant. The court's own findings were reinforced when it sustained as many as 11 objections on attorney-client privilege grounds, and sua sponte, which means on the spot of its own volition. It's a Latin phrase, sua sponte, prohibited defense counsel from invading attorney-client privilege 3 additional times. That's the problem. That's exactly the problem, because the judge's decisions were rooted in claims made by Terrence Bradley of, I can't talk about this because there's privilege. And then he later displayed, I just say there's privilege when there is no privilege because I don't really know what privilege means, which makes the judge say, well, then I was reliant on you the whole time. when you said privilege, I sort of trusted you as someone who was competent in making that determination and saying, yeah, okay, well, if you said it's privilege, I'm not going to let them ask the question. But clearly, you don't know what the hell the term means. So, yeah, now I got to do a little digging to figure out whether or not there really is privilege, because I can't rely on your idiotic interpretations. And that's a problem, because all this time, the defense tried asking questions, and you said there was a privilege, and you couldn't answer. I sustained it because of what you were saying, and I didn't realize you were an idiot. So what am I supposed to do? So now I got to dig deeper. The exact problem you have with this motion, the reason he has to have the in-camera proceeding is because there's 11 times that objections were sustained. I'm going to tell you something. If there were never any objections to attorney-client privilege that were sustained, he wouldn't have to do this. It's precisely because they were sustained that he has to have an in-camera, behind closed doors, decision-making process to figure out whether or not there's a privilege. And the only way he can do that is by investigating the nature of the conversations that they had. So he's forced to do this. That's why the judge actually made that statement there, where he actually said, excuse me, that's why the judge actually said this.
Bradley previously testified that the reason he left the firm was totally and completely covered by privilege.
See, he said the reason he left. This is how the judge discovered that Bradley, sitting there looking all confused in the lower corner there, and don't get confused because there's 2 Joes on screen here. I just, but he said, I can't talk about what happened to the firm because it's privileged. And then,
when asked by the state, he went into a factual scenario that, to my mind, I don't see how it relates to privilege at all.
Which means that he said there was privilege when we know, as a matter of law, there was no privilege. Thanks to the state asking these questions and drilling him about the nature of why he left the firm, the state exposed Bradley as being incompetent on making determinations of when a privilege attaches or does not attach.
And so now I'm left wondering if Mr. Bradley has been properly interpreting privilege this entire time.
Now I think he doesn't know what the hell he's talking about. And since I see he doesn't know what he's talking about, and I made all these rulings sustaining objection privilege, because and then turned to him and I said, well, is there privilege here? And he said, yeah, there's privilege here. So I said, okay, sustain. And now I see he was an idiot. He doesn't know what the hell he's talking about. That's what Abby Cross, counsel for the state, did when she unraveled him. Good job, Abby. Good job. Now comes this motion which says, hey, you made these rulings. You said there was privilege. The court is well aware of the fact that the reason they made those rulings is because they were reliant on Terrence Bradley's claim that a privilege was there, and then later learned the guy's an idiot. So, no, there might not be privilege, and the only way I can figure that out is if I have these in-camera proceedings that you're bringing a motion saying, please don't look. Please don't look. We're terrified you're going to look at. Why are you so afraid, Nathan Wade? Why are you sweating, Nathan Wade? There's only one reason for him to be sweating. I can't come up with any other basis. And here's what's so delicious about this. There's no other logical reason for him to be this afraid to make this stupid, illogical of a motion to stop the court unless he knows that with almost without a doubt, the judge is going to see he committed perjury. And that Fannie Willis committed perjury. Because Bradley has the goods. And the reason we think Bradley has the goods is because Bradley initially said that, told Alice, what's her name? Ashley Merchant, that, yeah, I got lots of stuff telling me that they had this relationship going on a while. And then later clammed up, saying attorney-client privilege. So, yeah, they don't want scrutiny. He doesn't want scrutiny because it doesn't just mean he might be off this case and the Fannie Willis might be off this case. It means they might be disbarred. That's my personal opinion. My personal opinion is that both of them committed blatant perjury. Given facts, circumstances, the way the parties are acting, the way the testimony has come out, I am telling you that in my own personal opinion, both Fannie Willis and Nathan Wade committed perjury when they claimed that their relationship was not in existence on November 1st, 2021, and that they are terrified that this will be exposed when the court conducts its in-camera examination. And that the ramifications thereof are that they can both be in serious trouble. Accordingly, the court has already determined that any statements made by Wade to Bradley within the course of representation related to the subject of representation are absolutely privileged. And neither Wade nor Bradley can be compelled by the court to disclose these communications, even in camera. Yeah, the reason this is such a stupid, pathetic motion is because the court is well aware of the fact that it made those conclusions because of Bradley's idiotic representations about privilege, when he's an imbecile when it comes to ascertaining the existence of a privilege. So the court knows that all of those decisions it made are invalidated because they're reliant on a moron. They just didn't realize he was a moron at the time they made those determinations. Bradley testified that he has no relevant personal knowledge and he sought advice of both counsel and the state bar, Georgia attorney-client privilege prior to his testimony. So? So? These are admissions made by Wade. That's what he wants to find out about it. So you can go on here about how you as counsel and attorney Bamel Chopra, licensed practice law in 29 years. Bradley himself has been licensed. Who cares? Yeah, he's licensed for practice law in Georgia for 17 years, and he still doesn't know what the hell privilege is. Both have spent their practice primarily representing clients well-versed in the boundaries of attorney-client privilege. Clearly not. Maybe Mr. Chopra. I can't judge Mr. Chopra. I have no way of knowing. I would assume he seemed like competent counsel when he was there at the hearing. I would assume he probably has a better grip on what privilege is. But certainly Mr. Bradley don't. Even so, I have abundance of claims. Bradley testified that he and his attorney sought advice in the state bar of Georgia to ensure that he would not improperly disclose communications protected by attorney-client. Yeah, but then he displayed he doesn't know what it is. And that if there's, when in doubt, even if there is no privilege, he'll just say privilege. Can't say privilege. I can't say privilege. Really? So what did you and Wade eat for lunch when he first told you in 2015 that he wants to retain you? Can't tell you. Privilege. And the judge all along was like, I don't know that my interpretation of privilege is as broad as yours is. Like he was arguing with Chopra, Bradley's attorney, and saying, I'm not sure that it covers. He's like, are you making a claim that once he has this conversation in 2015, that every communication they had for the next 6 years is privileged? He's like, no, but things about the relationship. So, okay, I guess, maybe. Out of abundance, this judge clearly respects attorney-client privilege so much so he's like, I don't want to risk stepping there. But now he's forced to. And the only reason he's forced to is because Abby Cross, counsel for Fannie Willis, tried embarrassing Terrence Bradley. And to me, that's delicious. It's delicious. Because I'm going to tell you something. I haven't expressed this yet, but I'm going to say this now. I was very bothered by the cross-examination that Abby Cross did. Because she was basically looking to punish and humiliate Terrence Bradley. That's what she was trying to do. She was trying to humiliate him. And she basically starts saying, who's Anna Rodriguez? And isn't it true that the reason you left is because these allegations against you, that you had touched this woman inappropriately? And what about this trip that you had to a strip club? And what was that about? And this other person witnessed you. And this staffer of yours, this junior attorney was with you, and he saw you touching a woman inappropriately at some nudie bar or whatever the heck, I don't know. And how and that's why you got really, that's why she was trying to humiliate him. Why? Because he had the audacity to show up in response to a subpoena that he was legally obliged to show up and answer. There's all sorts of intimations that he was threatened by other attorneys who were basically telling him, don't go. Because we all know they wanted this case to proceed as swimmingly as possible. And messages like, remember your oath to respect the attorney-client privilege, like from other attorneys who are more senior in the Georgia circuit. So all these different threatening things, and he did follow their advice. He really clammed up a ton, more than he was supposed to, by saying this attorney-client privilege, even when there wasn't. And then Abby Cross gets up there and she just doesn't like something about the way he said something. And she feels like, I need to try and impeach him by humiliating the hell out of him about facts that have nothing to do with this, and try and tell the world that women call you a gross, disgusting toucher, whatever, essay person. Multiple women accusing you sicko, under some sort of backward theory that the reason she's doing it is to show that he has bias against Wade. I don't know, unless he touched Wade's sister or mother. I don't know how it is that would create a bias with Wade. That shows that. But to me, the reason this was gross and disgusting is because she wanted to punish him. That's what she wanted to do. It looked like she was trying to punish and humiliate him. I saw him there in the stand. I was saying, like, if you watch the stream, you'll see me there. I'm like, but it's also like, why? Why are you going through this? And I even made a comment in one of those clips, like, I don't even know why she was there. Is this really helping Wade? And the judge is like, why are you trying to do this to him? And the fact that those questions are potentially the key questions that alerted the court to Bradley's ignorance about understanding the law as it applies to attorney-client privilege, or at least privilege in general, and now might be the undoing of Wade. To me, chef's kiss. Beautiful, beautiful, beautiful. I'm so happy to watch you bury your stupid, lying, perjurious client whose life is dedicated towards political persecution. So you can rot. Watch your law license burn, thanks to having a moronic attorney sitting there trying to embarrass Terrence Bradley. Like it's so sweet to see that. It is so sweet to see that. What do you got here? What do you got for me? There's a little bit more that I want to cover in this before I start getting into humanities. Judge ordered a motion to compel for contempt. Person then lied to get out of contempt, and it can be proven 24 hours later he lied. What can happen? Judge ordered motion to compel for contempt. Person then lied to get out of contempt. And it can be proven 24 hours later he lied. What can happen? You can face criminal charges. In theory, there could be the court can. It depends on the jurisdiction. I can't answer this question. Depends on. I don't know if you're talking federal court or state court. I don't know if you. I wish I could help you here. Compel for contempt. Could be sanction. It could be a bench warrant. I'm not sure even in this context whether or not he showed up or he just gave an excuse. He lied and made up an excuse to not show up. In theory, the contempt order could be signed by the judge saying he gets thrown in prison. Charges could be issued for if he made those claims under oath. I don't know if he made those claims under oath. This is really, I really need a lot more detail here. If you try asking me and you spell more detail in locals, I can try and help you out. But I'm not promising they're going to have anything that's going to help. There's an obvious solution here right in front of us. All Trump must do is quickly sell 890,000 pairs of new gold kicks at retail cost of $300. When is judge ruling on this or more hearings? We're going to have closing arguments at the very least. We don't know whether or not there's going to be more testimony. Look, could the judge grant this motion? Yes. I will be astonished if he grants this motion because this is such a stupid motion. It makes no sense. Didn't Cross delete a text from Merchant's phone when she looked at it during Bradley's testimony? Unlikely. Brendan said she couldn't find the text when she got her phone back. Well, that's weird. Did she really not take screenshots of it? Because that would be weird too. That would be pretty stupid to not take screenshots. That'd be really weird. Thank you. It was probate court judge ordered it. Probate court is a whole different matter. It really depends on the jurisdiction. It depends on so many different factors. If you got on the phone with me and asked me this question, I probably would have 15 more questions to ask you before I can give you any sort of perspective on it. So I'll tell you right now, you're probably burning money in super chats trying to get me to answer. I'm not looking to have you burn money asking me questions that I'm still going to be left torn about what the answer to your question is. So since he said I have no personal knowledge of when the beginning of any legislation between Wade and Willis actually happened, I was not there. I do not have personal knowledge. That's not what anyone's asking about, though. No one's asking about that. All the questions were about what he was told. And there's no hearsay exception because these are admissions, his declarations against interest. When asked by the court, Bradley lack of personal knowledge included anything Bradley may have seen or heard outside communications with Wade. He unequivocally answered, "That's correct." Not relevant. Not relevant. You're wasting the court's time with this idiocy. That's not at all relevant to this because no one is talking about his personal knowledge. That's not what this issue is about at all. This is like fluff, like you're trying to just like make your motion more than 3 pages. Georgia law clearly prohibits compelled disclosure of the attorney-client privilege communications at issue, even in camera. Okay, so what if the fact that it's inviolate, so they're trying to say even in camera, that's still considered breaching the attorney-client privilege? This is important for their motion if their motion wasn't already scuttled by the fact that the issues you brought up 2 pages ago make it astonishingly clear that the judge must hold something in camera to make a determination as to whether his previous rulings were in error because they were reliant on the claims of a moron. Like it's so stupid. It's so stupid. And the only reason he would file this motion is because he's terrified. Bradley must hold so much damning information that. And the only information we hold in that could be scaring this much is that there was a relationship that long preceded November 2021, which means that both Fannie and Wade committed perjury in this court in front of this judge. I mean, outright, flat, 100% lying to the face of this judge. I'll tell you right now, that ain't. I think it's at least 50-50 they're gone on the Trump case. And there's a really good, we don't know what's going to happen in camera. We don't know how thoroughly he's going to drill Bradley. He might just give him a test. Say, here's a written exam on privilege. I want to see what you understand about attorney-client privilege. Answer the questions on this exam. He might do that. He could do that. And if he answers satisfactorily, in that case, he might say, all right, he's confused about privilege in general, but he understands when it attaches in an attorney-client setting. So I don't need to dig any further. He literally could do just that. But the fact that they filed this motion, if I was a judge, I'd be ticked off. I'd be like, you don't want me to dig into this? Why are you so afraid? Why are you so afraid? This is crazy. I mean, if Judge McAfee isn't thinking right now that the chances that they committed perjury are very, very, very high, very high. Now, he might not want to find that they committed perjury. That's possible, because if he finds that they committed perjury, if he digs a little bit and unearths obvious perjury, he finds these text messages where, he's talking about the relationship. That's something that he then has to start making all sorts of decisions about whether he's going to report them to the Georgia Bar Association. Okay. And theoretically hold him in contempt. Trying to deceive the court by lying under oath. I mean, seriously, this case has lots of issues, and it's delicious to me. When they start talking about different cases, I don't care about these stupid cases where they start showing that in camera is the same thing, and that's still considered a breach of its. That's still considered breach, dipping into the attorney-client privilege. It's really not relevant. It's not relevant in the sense that, okay, I'll give it to you. Let's assume that would be a breach of attorney-client privilege for the judge. Let's assume I give you everything that you're saying on that. That's only once we know that there is an attorney-client privilege. And the one thing we know for certain is this. Today, right here and now, the one thing McAfee knows for certain is I don't know that all those decisions I made saying that attorney-client privilege prevents Bradley from talking were rooted on the perspectives of someone who understands the law about attorney-client privilege. And I don't have confidence, because this is a guy who clearly just says privilege, even when there is none. So I don't know that I trust him when he says there's privilege. And the only way I can establish that is by asking him more and more questions about what he was told and the nature of those conversations. And was it seeking out advice? Were there ever times that he spoke to you about things that had, how long did you go in gaps between talking about getting a divorce? Did you go a year or two without talking about the divorce? During that time, were there ever any discussions about Fannie Willis? It doesn't make sense to say that every time he brought up Fannie Willis, that is attorney-client privilege. Even that was something that Chopra had to admit. So if he says, hey, I met Fannie Willis, imagine this situation here, and this is one of the things that Judge McAfee sort of made allusion to when he was debating this with Bradley's attorney Chopra. He's like, so if he says, hey, I just met Fannie Willis at a function, is that part of his getting counsel for his divorce? Obviously not. That's a start of a relationship. So then if he says, oh, I had dinner last week, is that with Fannie Willis? Is that also part of his conversation? Along the way, Wade ends up recommending Bradley. That's part of the testimony. Wade recommended Bradley to Fannie Willis that he should be hired to be part of her taint investigation. And yes, it sounds funny enough that you can giggle about it all you want. But the bottom line is this. When Wade comes to Bradley and says, hey, I spoke to Fanny and she's going to talk to you about you becoming part of investigating taint, is that privileged? Because it's part of his representation of him as a divorce lawyer? Obviously not. There's direct conversations about Fannie Willis specifically, almost assuredly, dozens, if not hundreds of them, that had nothing to do with Bradley's representation of Wade in the divorce proceeding. Conversations about Fannie Willis that certainly have no ties whatsoever to the divorce proceeding or an eventual divorce proceeding, or that Wade could say, oh, the only reason I told him about Fannie Willis and the whole taint thing was because I needed his counsel for my divorce proceeding. That doesn't make any sense. So similarly, if he's talking about Fannie Willis in context A, B, C, and another context, we know they're friends. Another context that you're talking is that he says, hey, last night I told Fanny that I love her and like whatever. Who says that's part of his divorce proceeding? Why would that be part of his divorce proceeding? Does the divorce lawyer need to know the extent of your feelings for a woman? Yeah, I can recognize that if he says, hey, I can't, if he came to Bradley and he's like, hey, I don't want to deal with depositions about this issue about my infidelity because I had a relationship with Fannie Willis. Okay, that's part of getting counsel from him as an attorney, divorce proceeding. But there obviously were many, many hundreds of conversations between Bradley and Wade where the name Fannie Willis was invoked that are definitely not covered by attorney-client privilege. And here we have a guy who clearly does not understand when and where privilege attaches. And we just relied on him throughout this entire hearing to say, oh, that's privilege, that's privilege, that's privilege, that's privilege. And he seems to just throw around that term privilege a lot, even when it doesn't apply. So, hypothetically, if Trump had 800, we got this. Problem for Wayne Willis, Bradley is a nice guy. And I'll tell you this much, another stupid thing is, like during Abby Cross's cross of him, she's like, you're not friends, are you? He's like, I thought we were friends. When did we become not friends? I thought we were friends. Oh, you're very welcome. You're very welcome. Anyhow, so it is delicious to watch them sweat. I am very, very much enjoying it. Very, very much appreciating it. Really looking forward to this motion. Now, we don't know what's going to happen in camera because, well, it's in camera. That's one of the drawbacks about things being in camera is that, well, we don't get to see it because it's in camera. So, but it is to just watch Nathan Wade sweat. I'm telling you right now, this is obviously not a statement of fact. My personal opinion, I believe Nathan Wade lied on the stand. I believe Nathan Wade lied in his affidavit. I believe Fannie Willis lied on the stand. I think there's a lot of evidence that they both lied on the stand. There's a lot of evidence that there was a relationship there. And the more concrete that evidence becomes, the more terrified they should both become. That not only was this case going to slip away from them, but their entire legal careers could slip away from them. And if so, you earned it. You earned it. You're not enhancing the legal profession. You're just making it worse. A lot worse. A lot worse. All right. And that's it for this segment right here. It only took me an hour and 30 minutes to get through that. I got a lot more stuff to cover with you, though. I specifically want to get into humanities. I'm going to get into humanities with you all. Let me make sure I didn't miss anything because it's very, very possible I did. I don't think I did. We're good. We're good. I was just checking on my locals, on my diggers and locals. Okay. If you're not sure, I don't call them diggers because I'm a Jew digging tunnels. That's not why I call them diggers, okay? No, the reason I call them diggers, no. The reason I call them diggers because I'm talking here for the last hour and a half about Nathan Wade potentially committing and Fannie Willis potentially committing perjury and the dire straits they're in. And they're talking about, no, we have Google Fiber here. It's only Spectrum. But Spectrum just came through the area. They have to actually run the internet. And this is what's happening. This is what's happening over there. And my thinking is, you know what? If they're watching me in the background and they're having their own conversation and they're happy, that's fine. That's fine. Just dig away. Dig away. You're happy. You're happy. As long as you're happy and you're here, I'm good. I'm good with it. I'll just blah, blah, blah myself. Blah, blah, blah myself. All right. I want to share with you this. So last night, when I was talking about Biden and the whole direction of how they handle stuff and their policies, I made a statement that I was called out on in Twitter, and I thought this was a fair thing to call me out on, very fair thing to call me out on. So Elemental Jesus said, on the never attribute to malice maxim, which is what I said yesterday was never attribute to malice that which can be attributed to stupidity. Which, those of you who are unfamiliar with that term should understand what it basically means is when you're looking at someone doing things that are wrong, why are they doing these wrong things? So we're very quick often to say because they're evil. Whereas often, it's not that they're evil. The motivation is not that they're evil. They're just stupid. And there is a maxim, a phrase, a saying, which says, never attribute to malice that which can be attributed to ignorance or stupidity. So don't assume that there's an evil intent. Could just be they're idiots. A lot of people are idiots. A lot of people are idiots. So Elemental Jesus pointed this out. He's like, how is this not recognized as a fallacy that gives the malicious people an out by pulling the stupidity or incompetency card when they get caught? It's feasible to malicious people will bake incompetence and stupidity into their actions. And I thought that this was a great point. And the reason part of the reason I thought it was a great point is because I thought the same thing. I had the exact same thought myself. The first time I heard this, I was like, well, if I was a malicious person, I would pretend that it was based on stupidity, even if it wasn't. Play ignorant, right? So I'll ask you, is the saying true or is it not true? Maybe the people who we think are stupid are really just actually clever, evil people who, when they're called out and exposed, are like, oh, I didn't know better. But they really are evil. Brian Watkins says, Wade is trying to keep Bradley from testifying because of the way they tried to assassinate his character on the stand last week and knows he's probably going to spill all their secrets. I think he knows. I think this is the nature of what's in those secrets that's scaring him. And I feel very confident that what's in those secrets is that relationship was going on well before November 2021. And there's a bunch of reasons to think that. Number one, that's what Ashley Merchant thinks based on text conversations she had with Bradley that before Bradley got clamped down by the outside. Number two, we have her friend who is saying the same thing. Saying the same thing. The relationship was going on for years before March 2022. So it's the second reason to think that. Number three, they're terrified. Why are you so terrified? Why are you trying to scream attorney-client privilege over and over and over again? Why are you not waiving it? Wade could waive it. He could waive it. Think about this for a moment. If in fact there was no relationship, don't you think he would waive it? Don't you think he would waive it? If the first time he actually started hooking up with Fannie was in April 2022, and he came back that day after an April Fool's Day, it's like, dude, you're not going to believe this. I just nailed the DA. Don't you think that Wade would waive the attorney-client privilege? So this way Bradley can be like, oh, yeah, No, the relationship definitely started in April 2021. I remember him coming into my office, and I was sitting there. It was a spring day, and I just finished watching. I was just finishing watching the Final Four. And it was in 2022 in the Final Four of March Madness. And it's like, yeah, don't you think he would come? He would say, "I want you to testify." Unfortunately, Wade wasn't drilled on that hard enough, I think, by defense counsel. Defense counsel could have drilled him and said, why aren't you waiving it? This is not a Fifth Amendment right against self-incrimination. It's not the same thing. It's not the same thing. Plot twist. Bradley blackmailed Wade and Fannie for the sweet teen money. Now hiding behind privilege, protect them all. Ooh, that would be. That's sweet teen money. I love me some of that sweet taint money. I love me some of that sweet taint money. That was my best French accent right there. So, obviously, my French accent. First installment toward the Tom Jones cover, leaving balance of $190. I think I said 1,000. No, I might have said 200 on Tom Jones. I don't remember. That's not how this works. No, I'm not keeping tabs on that. No, I reject your assertion. My brother. It's not unusual. I don't even know if I know Tom Jones. Well, what's that pussycat? What's new pussycat? That's what. We'll see. No, that's not where I'm going to get. Okay, so back to this question that I asked you all. So, what do you think about this? And if you're watching afterwards, you can drop a comment down below. Do you think that this is untrue? And the reason it's untrue is because, of course, the evil people, the malicious people, are going to lie and claim that the reason that they weren't guided by evilness, they were just mistaken, stupid. I'll make a note to last night on the following program that he's checked like at 1:40, an hour 46 or so. All right, there you go. Not that I'm in communication with him on a regular basis, but yeah. I don't remember promising in the $10 increments. I don't know I don't know about that. I gotta think about it. So here's why I think that this argument is not really relevant. And I want to explain something to you about, and this is why this is part of humanities, okay? The reason this is not part of it is because you have to ask yourself, when you're saying the phrase, never attribute to malice that which can be attributed to ignorance, ask yourself this. Are we applying that maxim, that phrase, that philosophy in a courtroom? No. We're applying it really in the court of public opinion. So, what is the fear? What is the fear in misattributing it? When you take the phrase never attribute to malice that which you can attribute to stupidity, what you're really saying is, look, we are in the court of opinion. Do you know that Biden is evil? Well, yeah. Okay, there's a lot of evidence that he's evil. All right. Do you know that Lindsey Graham is... Okay, so there's a lot of evidence that he's evil too. Do you know that Dan Crenshaw is evil? Yeah, he could be stupid. I don't think he's stupid. The point being, it could be that you as a person, the reason I think that this is a healthy credo is because you as a person are better off if you look to give people the benefit of doubt. Does that mean that sometimes when you're giving people the benefit of the doubt, they're going to dupe you? And they're going to say, no, I'm really innocent. I just didn't know better. And you'll be like, okay, fine. I guess you didn't know better. Let's assume this is the scenario. Now they were lying to you. They really did know better. And they just fooled you. And you swallowed it. You accepted it. Where is the harm here? Where is the damage here? The damage is basically, because if you think about it for a moment, they still end up doing the wrong thing. Whether it was motivated by malice or stupidity kind of doesn't matter in most scenarios. Kind of doesn't matter in most scenarios. The only time that would matter is if you're looking to protect someone protect an individual from being harmed by this person. So, for example, here I'll give you an example. Let's talk about the most terrible type of scenario. Okay, let's assume that somebody, I don't want to use the most terrible one because it's gonna be too gross. It's gonna be too gross in my brain, and I don't want to do that. I changed my mind. Let's assume someone set fire to a house. It's not a criminal trial. Okay? For arson. It's just, so now in that scenario, there's some people saying that it was malice, others saying he's just an idiot. He's just an idiot. He wasn't trying to burn the house down. He's just a moron who basically didn't realize that if you turn the flame up on your gas range and you leave a wooden bowl right next to it, that's a dangerous situation. So are you going to leave him in charge alone in your house? Probably not. You want to know why? Because he's an idiot. So where is the harm here? You already know to protect yourself from this person, not because they're motivated to do something bad, but because they're too stupid to avoid doing something bad. So you're already on notice, on warning, to stay away from this person or to protect yourself from that person doing more bad things in the future. So all you're left with here is whether you're thinking bad about them or not. So you can choose to think bad about them and assume that they're motivated by malice. And if you do that, all right, I mean, it's you have that prerogative to do that. But if you were to allow yourself to basically say, all right, you know what? Maybe you were just stupid. Maybe you're not evil. Maybe you're just stupid. Is that going to harm you? The only harm is because you know to stay away from them, even though they're just stupid. You know to stay away from them. You know to insulate yourself from being victimized by their stupidity. The only harm is to your ego, to your own ego. That it's like, oh, they feel like they tricked me into it. They tricked me into believing that their malice was just stupidity. Okay. And how is that harming you? If you're genuinely secure in yourself and you're not worried about like whether or not they think that, oh, I'm able to trick him, how is that harming you? I don't see where the harm is. So you as a person, I believe, will be a happier person. It's not that you're benefiting them, it's that you're benefiting yourself. Because if you're not sitting in judgment of others all the time and saying, oh, this person's evil, that person's evil, this person's evil, and say you say, no, maybe I don't know if they're evil. They could just be morons. So I don't think that the harm is to your own ego. But if you're able to be sufficiently confident in yourself that you don't worry that, oh, now this person who just tried pulling the wool over my eyes, I was willing to accept having that wool pull over my eyes to the extent that I assume that they're not evil. I don't see where there's harm to you other than your pride. And I think to the extent that we can just swallow our own pride, that just makes you a stronger person. To the extent that we can push down our own pride, you're actually a better person. So the phrase of never attribute to malice that which you can attribute to ignorance, that doesn't apply in a court of law because in a court of law, you go with the evidence. I'm simply saying it makes you a more powerful person if you embrace that, because you're basically not concerning yourself with looking like, oh, I'm like some stooge for like some empty story. I'm not worried about that. So that's the argument I would have in support of that phrase, of that saying. I don't know, but I'm wondering your thoughts on that. I'd love to get your thoughts on that. Look at this. I got thoughts on this. Anna P. When Fanny said she was going to emasculate a black man, she was referring to seeing him in 2020. Why didn't Stowe ask her how she knew he had erectile issues in 2020 if they hadn't been romantically sexually involved until 2022? I don't remember this, Anna. I don't remember that. I don't remember her. I remember her using the phrase about I would never emasculate a black man. Which is really interesting because the implication to me was like, so obviously you would happily emasculate a white man, but not a black man. I'm going to see. You sent me a really nice super chat, and I appreciate that. So I'm going to invest another moment in this to see if I can find that quote from her in the context. Fanny, I would never emasculate black man. That quote's not. I'll show you what I got here. My searches. Let's take the. See if that works better. I'm not going. Wade had a form of cancer makes her allegations somewhat ridiculous. She told defense lawyer Steve Stowe, I'm not going to emasculate a black man, so I don't think we should discuss it further. I don't. So now I remember the context better. I appreciate you bringing this to my attention, Anna. So yeah, he did talk about how he had cancer in 2020. Why didn't Stowe ask her how she knew he had erectile issues in 2020 if he hadn't been romantically sexually involved until 2022? I don't know that she was saying that he had ED. It could be that it was testicular cancer, and that would be embarrassing for him for that to be known. I want to see if I can find a transcript of Fanny testimony so we can get the exchange a little bit more. Look at that. I think I found it. From CNN transcripts. How can I control F this? Control F. Is this the wrong thing? It was on February. It was on February 15th. What is this? It's not go all the way. When was it 10:30? What the hell is CNN? You suck. Takeaways from Fannie Willis's stunning testimony. Stunning and brave. Stunning and brave. You gonna give me a transcript here? Bastards. Give me a transcript. Oh my gosh, this is so bad. The fawning is just gross. So gross. These idiots. These cucks. These cucks! God. I'm going to find the word emasculate here. No. No. But I didn't look at it. I didn't look at it as her talking about her sexual thing. I looked at the whole emasculation thing. My recollection is I looked at it as being something that I don't want to talk about his issues with his Johnson that he had in 2020. And she could have theoretically known about that even if she was not dating him. So, Joe, I couldn't agree more. I've always done my best to listen to the best people until they prove me wrong. Yeah, it's a healthy way to live. I agree with you. Yeah, like protecting banks from Trump. Are you attributing to malice? Is that what you're talking about? I'm not sure where this context is. 11:54. That's 10 minutes ago. That's when I was definitely talking about attributing to malice. I don't know. I'm not sure what you mean by that. I'm just stupid that I excuse others' maliciousness for ignorance. It's not. That's what I'm saying. It's not stupid. It's not stupid. It doesn't harm you as long as you keep yourself safe from the ignorance of others. How's it harming you? I think it keeps you happier. Pretense to ignorance while being evil would be sociopathic. The expression rings true because most often the pretense is excuse after the fact, like the mob boss in the wheelchair and pajamas. Yeah, that's a criminal setting. In that criminal setting, that's different. In criminal setting, I wouldn't say the same thing. In criminal court setting. A vote for I Put a Spell on You. Also, that's a Tom Jones song? I don't know that one. Also, I've listened to Fanny. Eubonics is now a recognized language in U.S. courts. I'm asking you. When she was talking about him having cancer and not having contact with him. Yeah. That is interesting. That's an interesting catch that you made there. That is a really interesting catch. I remember thinking that she was saying because he was in a medically weakened condition, and it was 2020 when COVID was going around, then everyone who was medically weakened was considered at risk of getting, knocked off by the dreaded C word. And this word, in this context, not see you next Tuesday. But, so that's how I understood it. And then being asked, well, what was he dealing with? And she said, I'm not going to emasculate a black man, which is funny. Ironically, it's answering the question. That's the nature of the cancer, right? But I don't know. I could be mistaken on that. That my recollection at the time was not to see what you're saying, but that could be my miss and your get, if that makes sense. And I can't put my hands on the transcript despite my best efforts in this limited time span. So it could be you're right. I remember it differently, but I could be wrong. Is woke like a box of chocolates on 110 degrees Tay? Completely melted? Oh, I see what you did. There's not proof of romantic relationship. It could have just been casual statement at the water cooler. Wade, good morning, Fanny. Good morning, Fanny. I can't get it up, Willis. Willis. Oh, I'm sorry to hear that. That's true. You're saying it in response to this. Could be. Yeah, I agree with you. In fact, the judge agreed with this so much that he basically implied that even if they had a sexual encounter, this was shocking to me, that he didn't allow testimony about the nature of their sexual relationship. And he basically implied when a question was being asked, like he's like, I don't want to hear testimony about that. That even if they had had sex before November 1st, 2021, that would not be proof of relationship. Which, what? How is that not relevant? That seems highly relevant to me. But see, that's not protecting yourself. That's not protecting yourself. Because even if he's ignorant, that doesn't mean that you still need to protect yourself. Which anyone who's abusive, they're not being. I don't believe that they're ignorant. I think that, but my point is, if you attach, even if you were labeling ignorance, I'm sure you were. I'm saying is, even if labeling ignorance, that doesn't mean you can just ignore the fact that his ignorance is leading towards your harm. So if you let that boundary get pushed, which only a jackass would ever push in the first place, but if you let that boundary get pushed, yeah, the boundaries just get worse and worse. There's no limit. I'm sorry to deal with that. If you Google Fannie Willis trial transcript erectile dysfunction, there are results. And yes, I was talking about the malice, ignorance, and the other super chat. Oh, okay, so good. All right. That was the first thing I wanted to cover. Next up, making sure I didn't miss anything, because that could happen. I did miss a few. We're making sure I have internet when I move so I can catch your stream. Good job, Beak Boop. Love Humanities. Can we cover this next time? It covers in part border crossing. What? What do you want from me? What's the shot? Scary Islam is recruiting woke, useful idiots. It's an hour long. That's an hour. That's a lot. That's a big ask, Worcestershire. That's a big ask. Plot twist, Bradley and Wade were a couple before Big Fanny got in the way. That's pretty funny, fans. That's pretty funny. All right. Where was that? Okay. Next thing I want to cover is Ray 1210, and I had two more topics I wanted to cover. Okay. Sorry if you already covered this, but what do you think the judge is going to rule tomorrow on Wade's filing? I don't know that he's going to issue a decision tomorrow on Wade's filing. I think he's going to deny. I think he's going to deny the application and hold the in-camera proceeding. He may ask Trump and Ashley Merchant and Sado to weigh in first, but I don't think he's going to grant this relief. I think he's going to have the in-camera. I think everything if that's the, and I did cover this. I spent a long time basically saying how this motion was terrible, terribly illogical. And I have enough confidence in this judge that he's going to see through the utter illogical elements to it. Because basically they're saying you made a ruling before, you have to stick behind it. When the judge knows that ruling was rooted on an expectation that Bradley understood privilege, and that when he says I can't talk about his privilege, that he knows what he's talking about. And the reason he's having this in-camera thing is this in-camera analysis, this in-camera examination, is because Bradley later showed that he has no idea what he's talking about. And the judge upheld his interpretation of privilege 14 times and didn't let the defense ask relevant questions because it's privilege when it wasn't or may not have been. And we don't know if it was until there's an in-camera thing. So now Nathan Wade is coming along and saying, oh, you can't, are you already ruled on this? The judge knows why he ruled on it, that he was relying on an idiot. He just didn't know at the time he was making the ruling that the guy was an idiot. He assumed he's an attorney who understands what privilege is. So it's a stupid argument. It doesn't make any sense. It's like the whole reason he's doing the in-camera. The whole reason he said he wants to do the in-camera is because he's like, I can't rely on those rulings I made earlier. So what are they saying? Oh, you can't look at this anymore because you already made a ruling. He's like, but I have to look at this because I don't trust my rulings. That's not even, it's not even like anything. It's not even emotion. It's not anything. It's stupid. It makes no sense. If I come to you and I say like, if I come to you and I'm like, it's hard to come up with an analogy off the top of my head, something like this, but yeah, this person's entitled to a lot of. This country's entitled to a lot of foreign aid because their people are starving. And then afterwards, you know, your source that told you they were starving is like, oh, I've never been to that country. I don't know anything about it. And then you're like, you can't look at it because you already ruled that they're starving. What? I was relying on someone who was never there. And that doesn't make any sense. Doesn't make any sense. I got to look at it further. And you're like, well, you can't look at it. You think the judge is going to buy that? No, I don't buy it for a second. I don't think the judge will buy it for a second. I don't buy for a second that the judge will buy it. I think that they have less than a 2% chance of succeeding in this motion. That's how bad this motion is. I think 2% is being generous. I think it's an idiotic motion. And it's an idiotic motion which displays how terrified he is of the judge actually looking at and exploring this any further. All right. So next topic I wanted to talk about here. Oh, yeah. This is what I wanted to share with you. Where are you? There you are. I thought this was a really interesting humanities thing. So it's sort of humanities, and it's sort of about the topic of border.
Try and corner Douglas Murray.
This guy here, he finds great clips, like a lot of great clips that he finds. He adds no content to it at all. He's one of these classic, like, nod and listen. He does like a little intro, says nothing. He adds nothing to it. He's got a couple 100,000 subs, I think. And I'm like, this guy's a thief. He's a thief. Let me refresh this and hopefully.
Some very dishonest people try and corner Douglas Murray in Qatar, of all places. Check it out.
To what extent can we really sell this idea that being educated or fitting X, Y, and Z criteria is what you need to do as a refugee for people to humanize you?
Dehumanizing refugees. Thank you very much. And with it,
this woman here seems like the classic Beyonce. Thank you very much for your question, and I'm going to turn that over to you over here. I'm very important. I'm the one who's deciding. It's like, I'm going to turn this over to you, Douglas Murray. This is not going to blow up in my face at all. You're dehumanizing refugees by asking them to embrace the culture that they're in. That's essentially. So why is it fair if people are refugees, or I guess asylum seekers or whatever, to expect them to become part of the culture? Why? Why is that fair? And he gives an answer.
yes, let me go to you, Douglas Murray, because much of your argument, Douglas, seems to be about their values, their traditions. You seem to almost suggest that they come to your countries with a lesser breed of values.
What the problem is here is that
So by asking them to embrace your culture and your values, you're implying that yours are superior. That's sort of imperialistic type of perspective, that you have superior values. They have to subjugate themselves to your values because your values are implicitly, inherently superior. So this is Douglas's response.
These things are all rubbing against each other. And in that situation, you have to work out what things you're willing to give up, which things you're willing to compromise on, and which ones you're not. You're not going to persuade the Brits to massively change their culture. But let me just make the point. Every single society has certain aspects of it doesn't want to give up. This one will. In Qatar, this one will. Everyone does. So please don't try
Which
to
of
make
your
this a kind of
values?
bigoted
Which of your
European
values?
thing. That would be a very dishonest
but I
way
think
to
the question-
Just answer
represent
this question
debate.
directly.
So this is when he brought up this one here in Qatar, their values. What this made me think about was this, and this is something that a lot of people on the left, I think, try to say is like, we need to show more respect for other cultures. So when you force them into a melting pot and saying that their culture needs to melt away towards the American culture, so that is that's like in some way wrong, morally wrong, that there's a moral issue here where you're claiming superiority of your culture to their culture. Because if theirs were superior, then you certainly wouldn't, if you thought theirs were superior, you certainly wouldn't force them to melt that away. So you're claiming that your culture is superior. So I want to talk about this whole culture clash thing with you guys for a little bit here. In the sense that when he brought up Qatar, I was thinking to myself this. Imagine 25,000 Americans suddenly move to Qatar in a span of a couple months. Does anyone think that in Qatar that they would respect the Western culture? Does anyone think that for a second? And the answer is obviously no. Any Middle Eastern country, there's zero chance that they'd be like, oh, yeah, well, they let them do things their way. We'll do things our way. Every different cultures, reason people adhere to those cultures is because they respect their own culture. That's why they follow that culture. That's why they follow those ideologies, because they respect them and they look at them as being the right way to live. And culture can, in this context, can be from a religious perspective. It can be from a moralistic perspective. It can be countless different forms of perspectives. Just as far as like it could be a dietary perspective, like countless ways. But whatever you're using to define the culture. So there's no question that in any country, there's no country outside of the West. If you went to forget about Middle East, forget about Qatar and Muslims. You think if you went to China, they'd be like, oh yeah, we need to start doing things the American way and melt away our culture in favor of theirs. The only reason that there's an expectation of Westerners to accept this is because we are recognized, and we recognize in ourselves that we are exceedingly tolerant of other cultures. But this question is a form of weaponizing our tolerance against ourselves. That basically, because you're tolerant, you should subjugate your culture to whatever culture marches across your border. So what they're really doing is they're trying to weaponize our tolerance and the fact that we in the West are far more tolerant of other cultures, and saying now you should be forced, even though it would obviously never happen in these other countries which are far more intolerant. And if you went there, that they would basically crush your culture out of you in ways that we would never think of doing here. But that you should be, that is immoral for you to not embrace their culture. Embracing their culture would mean becoming more intolerant. If we truly embrace their culture, it's a circular type of perspective, which is self-destructive, because basically what they're essentially saying is you need to be so tolerant to the point, if you follow it all the way through, to the point that you should embrace their culture and then become intolerant. Like, what the hell does that even mean? It's so illogical to me. And this rush to use, and this is one of the things that I think we see in America a lot. I think, especially amongst the left, where it's like they use the kindnesses that are imbued into our system to try and punish us while labeling us evil for having these values. You're so evil that you think you're superior in your culture. Like that's essentially what they're saying. Like that you make these assumptions that your culture is superior. That's the mindset of someone who's very closed-minded and very intolerant. Okay, well, what would happen if we went over there? What would happen to us there? Oh yeah, our culture would be driven the hell out of us. Are you kidding me? Like, no way. Please. So why should we be different than them? Because we're more tolerant. So I'm going to weaponize your tolerance against you to say that you're now the bad people because you're more tolerant. There's so many layers of circularity here. It's like you're spinning around in a circle to come to this conclusion. But it sounds like the way they word it is something that sounds logical. Like, oh yeah, no, that makes sense. Like, why are you assuming that you're superior? It's like, no. These are the values I've embraced that we as a country have recognized are healthy values. And we're not just giving them away. These are things that we treasure. That's the point Douglas Murray was trying to pound home. And every culture has things about them. They say, okay, look, I can give in certain elements of it, but I'm not going to give in other elements of it. And those and you have to make decisions as to where you're going to draw those lines, and everyone's got to make their own decisions. But the fact that we're even drawing lines is that is a reflection of the superiority of our culture. Because in other places, they would not be at all tolerant. There's zero tolerance policy. You think that Xi is going to be like, oh, yeah, sure. You have to have your liberal perspectives about civil rights. Really? Is that what you really buy? Is that what you think? Holy moly. Anna P. Thank you for the generous super chat saying, I'm a legal immigrant, now citizen from an Islamic country, and I'm more American than most of these leftists. I have no doubt about that. I have zero doubt about that. We didn't lose our Christian Armenian culture by adapting to American culture. It's a shame that the left has such haters to the U.S. but admires oppressive regimes. Yeah, they really do. They really do. And the implication of their superior, of the fact, it's almost like, and that's every time Americans are called colonialists, imperialists, all that other stuff, all these ists, racists, all these different ists that they throw at us in ways that they would never, and judging us by a yardstick that they would never judge any other culture by. No other culture would face the extensive scrutiny that they give to American culture. I mean, think about this. Think about this. When they're embracing Muslim culture, where Muslims would stone trans people, stone a woman who engaged in any sort of infidelity, stone homosexuals, like literally torture and beat them until they were dead. And they will basically stand up and defend that culture as, their way of life or whatever. And yet, if you refuse to put she, her in your bio, you're a freaking transphobe racist who's a terribly evil person. I mean, look at the difference in the yardstick by which you as an American are being judged by these leftists compared to, the abhorrent, patently transparent abuses that are completely washed away. I mean, how utterly backward does that mindset have to be? And that what they're doing is they're trying to weaponize the fact that you care about being labeled a racist. Because if you didn't care about being labeled a racist, they wouldn't bother calling you that. They wouldn't say racist or transphobe to like these Muslims because they'd be like, because they know the Muslims would be like, hell yeah, of course. I respectfully submit that the only way to beat this is basically say, I'm not worried about. I mean, and this is something the right has been doing. It's basically, we don't care about your stupid labels. No one cares about your damn labels. You're idiots. No one cares. That's what ultimately ended up happening, where people are like, yeah, okay, racist, fascist. The only reason it's bad that they've been abusing those terms is because then when they actually see racism employed on their own side of the aisle, they don't recognize it anymore. When they're saying things like, oh, it's totally okay to refer to Clarence Thomas as an Uncle Tom, that's totally fine. Totally fine to assume that black people who are not crazy leftists are obviously race traitors, because it's fair for them to castigate that and you have to have only one mindset if you're a black person. That they basically are they think that any black who is revolting against Democrats is now somehow, a race traitor. Like, what the hell's wrong with you? So what do you think? They're slaves to your ideology? They're your slaves? They're your slaves in the voting booth? It's essentially what they're saying. They don't see the racism at all. When they start abusing the term fascist for anyone they dislike or someone who cuts them off on a highway is a fascist. And then they see fascism, and I don't want to call what Biden and his regime has done fascism, because it's not fascism. When we look at, actual fascism from 80 years ago, but fascistic tendencies, they don't even see it. They don't even realize it. People being silenced, people being politically persecuted, people losing their jobs. If they don't say if they say the wrong thing, Gina Carano, people losing their ability to voice their opinion. If the opinions that you're expressing, things you don't like, people facing more criminal prosecutions. Like, they don't see their own fascism, and when you call them fascists, they think, oh, you're just throwing it back at us, rather than like, no, you're really walking down a fascist road, as opposed to this stupidity where you basically say that if Trump signs off on the Keystone Pipeline, that makes him a fascist. It's like, what? What? How? Where? So, yeah. Thank you very much. I appreciate your support. It's very generous of you. Lefties land on Qatar and demand they can choose pronouns if you want somewhere you accept the nation's ideology. Precisely. Yeah, you do. You accept their ideology. That's the way the world has always been. Paradox of tolerating the intolerable. Yep. Tolerance requires a position of security in one's own belief, knowing different peoples can coexist. That's the opposite of catering to others. Yes, that's correct. That's completely correct. All right. Last topic I wanted to cover. Last thing I wanted to cover. Where was you? What was it? Oh, okay. This is going to be a little bit complicated. It's going to be a little complicated. I should probably save this one. It's already 12:30. I should probably save this one on divine punishment. I was driving my son back from the airport after I picked him up. He flew back from the Holy Land, and I picked him up, and we had, almost 2 hours in the car driving back. And I had a lengthy conversation with him about divine punishment and retribution and this. I really should save this one. I'm going to save this one for Saturday night. I'm going to save divine punishment for Saturday night. I want to flesh it out more. My son is very, very deep. He's a really smart young man. He's very deep. when we have these conversations sometimes, and I actually find that like I let it mull around in my brain for a bit, and I come to like, but remind me Saturday night. We'll do this Saturday night, okay? Saturday night, God willing. I'll talk about the whole divine punishment thing. And if I forget, if one of you can just tell me like there's not just divine punishment, but divine, it's accepting of divine punishment. That's what I need to acceptance, human acceptance of divine punishment. That should be enough to trigger my brain back to where it was. But it's really too long for me to get into right now. I didn't realize it was going to be 2.5 hours in when I first got to this part of it. And this is going to take me at least 45 minutes. For me, it comes down to the difference between tolerance and acceptance. Tolerance is living, let live. Acceptance is overtaking the culture. Tolerance and acceptance. Tolerance is living and let live. Acceptance is overtaking the culture. So you're saying when they're weaponizing tolerance, that's compelling our acceptance. I can accept that. I think I'm at least at the very least I'm tolerant of that position. See what I did there? All right. I'd like to get your thoughts if you're watching after the fact. Your thoughts on any of these topics. Let me know if you think that weight is going to go down in a sweaty heap. Big Poop says, you missed one of my super chats. Probably not your fault. Locals has been buggy. Oh my gosh. No. Okay, you just made me sick to my stomach. You just made me sick to my stomach. Thank you so much for that, Beak Boop. All right, this is the end of my show. I'm landing my plane here. I'm bringing this on in here. I'm gonna tell you right now that I do plan on streaming Saturday night. I appreciate you joining me here. I appreciate your participation and your support in the conversation, the dialogue. I like the whole back and forth here. I'm very privileged to have you guys all contributing into making this conversation awesome. And you do. Divine punishment. We'll talk about, I'll tell you right now, looking at, oh my gosh. Do it. I'm going to do divine punishment on Saturday night. It's too long. So, but I will tell you that the weekend's coming up. It's a very exciting weekend for me. It's going to be going out to my son-in-law's place this weekend, and I'll give you guys all a report on that. I'll be back here, though. I plan on streaming Saturday night. It'll probably be late. I'll probably start like, I don't know. A little bit. It's going to be like probably after midnight because I'm going to like have to come back here and whatever. It's going to be late. But yeah, I do plan on being a Saturday night, not going to be a Sunday night. You need to follow me on Locals, goodlodge.locals.com. It's free, totally free, no credit card, nothing. At least this way you'll know when and where I'm going to be this week. Otherwise, you're not going to know. I said that at the beginning. I'm not going to say it again. I don't like repeating myself, even though I do it far too often. With all of that, I thank you all for joining me. I'm going to tell you right now, as Beak Boop would have me tell you, if you're going to assume ignorance instead of malice, that'll keep you happy. But if you don't want to do that, you can find other ways to be happy. Stay happy. Eat the bugs. And as always, my friends, I say to you, good night. Have a great weekend. And Godspeed.